Welcome to Center for Social Dialogue. This is the 172nd session of the center. CSD basically stands as an open platform which invites all kinds of ideas to be discussed, shared, and exchanged. So normally we have no such restriction as this idea need not be considered. We accept every kind of idea along the whole spectrum. But normally we avoid extremes such as extreme left and extreme right, not because of any antagonistic approach towards that, but because we feel that they are not amenable for dialogue. This is the basic issue, because dialogue means ultimately dialogue shall end in some kind of exchange. If not, it may not be 100% exchange of ideas, but at least some idea must be there. So we avoid that only. And also, whenever we conduct a session, we always advise that Center for Social Dialogue is an open platform. At the same time, it always reminds the members and the speakers that there is something called as the Constitution of India, Article 19, freedom, right to freedom of expression, and there are certain limitations also for the freedom of expression. We request the members as well as the key speakers to keep it in mind. These are all the few areas of suggestions we make. This 172nd session of the Center for Social Dialogue, we have invited one scholar, young scholar, Malavika Nandivelugu. She's a lawyer based in San Jose, California, specializing in employment and business immigration law in the United States. She earned her BA LLB from Pendekanti Law College and practiced law in India before relocating to the US, where she pursued an LLM in international business laws from Loyola Marymount University, Los Angeles. During her time at Loyola Law School, she was awarded the prestigious Merit Scholarship. With her diverse experience in both Indian and American legal system, she is passionate about exploring the mutual lessons that each country's legal framework can offer the other. So today we are having a small discussion or dialogue on the comparative systems of law, legal systems of India and the US. So I welcome once again Malavika Nandivelugu to this session, and I had requested to take over the session. She can give her talk for about 55 minutes to 1 hour, followed by a discussion. Huh? So this is Malavika. Now you are welcome. You can present your subject.
రఘు గారు జనార్దన్ రెడ్డి గారు వచ్చినట్లున్నారు.
వచ్చారు, జాయిన్ అయ్యారు, నేను వెల్కమ్ టు చేశారు.
ఓకే.
Firstly, thank you so much, Raghu Garu, for inviting me to this. Comparing the one of the most powerful democracy and its judicial system with one of the largest and almost efficient judicial system is a very tough thing to do, and this opportunity is a very good thing for me. I have learned a lot. So before I begin, I just want to give my disclaimers. When I actually started preparing my PPT, it started out to be very clinical and very legal in approach. Over a point of time, I thought I should put my perceptions and real-time experience in Indian courts as well as US courts into place, so that we evidentially understand whether the systems are being worked at a ground level or not. So I have put a lot of my experience into the PPTs compared to the clinical study in the legal domain, so that even the layman could also understand. With that, I would like to start my presentation. Just give me a quick moment. I'm just trying to share.
No issues.
Um, looks like I have to share the old screen while I'm presenting, which was not the case in the earlier attempt I have done. But however, I'll continue my
No, no, it's okay now.
presentation.
It's okay now, Malavika. It's full screen now.
Yes, yes, the entire screen is being shared.
Yes.
So let me start off by saying when we discuss about judicial systems, we want to remember the forefathers of the Constitution. James Madison is the father of the American Constitution, whereas Dr. Ambedkar is known as the father of the Constitution. With them, I would like to start my presentation. So the objective of this presentation is I would be providing a very basic outline of Indian and American judicial systems, where I would also be elucidating on each level of judicial process, and I will also be pondering upon how governance and society gets affected by judicial system, which is the very objective of having a judiciary. I will be also talking about legislations and executive people trying to coordinate for the betterment of the society and governance. That aspect will also be covered. I will also be talking about what one country's judicial system, that is India or the USA, learn from each other. And we will also be talking about culture as an aspect of law and how it needs to be inclusive and be established as a matter of fact as a law, and the way forward from here onwards, how we should be taking forward. These are the small objectives I've set out for myself. So, to briefly talk about Indian legal hierarchy, we all know it's integrated system with Supreme Court, which is the apex court. Then we have the state courts, which are the states where the jurisdiction of the state is maintained by the high courts. And then there are district courts. Then district court also acts as a session court, and we have lower courts. Interestingly, we also have panchayat codes like local khap panchayats, etc., where sometimes the local people of a particular village who have the elected, not not exactly elected, but a chosen person adjudicating on civil matters, which are not of criminal matters. So we have that feature, whereas in US system it is completely different. So we have in 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 India we have high courts specifically for one particular state, and sometimes some union territories have together with one particular high court. They are attached, but in USA it is different. We have two, three states together for one federal court. So federal courts are the state courts equivalent in India. They have the state level jurisdiction, and also every state court in USA has a state supreme court, and the apex court of the country continues to be the US Supreme Court. One of the most interesting aspect about US judicial system is we have separate regulatory organizations which would be exclusively looking after all three aspects of the judiciary, that is, taking the cognizance of the case, who are the officers, and how the adjudication has to be done, which is obviously to the judicial officers. All three aspects of the judicial implementation is taken up by those agencies. For example, we have SEC, Security Exchange Commission, which exclusively looks into these kinds of matters. We also, in US, there are also some other agencies like tax appeals or tax codes. These are very specialized. I would not call them as quasi judicial per se, because they do have the legal sanctity to adjudicate on the specific subject matter expertise. Someone spoke.
You go ahead. Don't worry about it. I will be muting their mobiles.
I'm sorry. Yes. Uh, yes. So, yeah, this is with respect to Supreme Court, U.S. system of legal discourse. In in the U.S. legal system, we have to understand very importantly, there are different functions and there are different agencies for different purposes, and all of them have their own adjudicating bodies, just so that it does not come under the federal jurisdiction, and it also forms as some sort of matter to be adjudicated by a judge who is a generalist. So we have to understand they have given the sanctity of the different streams of law by recognizing them as their own judicial body. So I would like to delve more into pre-litigation matters right now. In pre-litigation in the USA, we have something called a demand letter, which is given by the attorney. Whereas in India, we send legal notice. In India, once a legal notice is sent, if the opposition is not able to respond to it, or is not responding to it properly, we have the course of action to go ahead and start the litigation. Let's understand, in India, when the compliance is not done for the legal notice, it goes into litigation. Whereas in a demand letter in USA, if the other party is not complying with what is requested and it's not understanding, it ends in a jury trial. So this is different. It goes into a trial, and it might be jury in all possibility. So it is civil litigation of India versus jury trial in the USA. This is a very fundamental and main difference. And discovery means evidence. So in India, the evidence is primarily led by Evidence Act. In USA, discovery is in multifold. There are evidence state-based laws and federal laws, and usually all of these are very different in both the countries. In India, if something has to be admitted, it has to be admissible by the law. Court has to give an order. Judge has that authority. Whereas in the USA, the attorneys have that authority. What has to be discovered and what is the part of the discovery which would be called as evidence will be decided by the attorney, the parties. They sit and talk about it before the litigation takes place. And I think this is a very important feature, because people can understand what we are going to fight in the court tomorrow. So that's one aspect which is very important to cover in pre-litigation. Sometimes we do have some motions which can take place even at a pre-litigation stage. For example, one of the parties does not feel the jurisdiction is good enough, or otherwise some sort of oral evidence needs to be taken even before the trial begins. All of these are possible in USA, but in India, pre-litigation seldom happens, or I rather say it as a rarity. So pre-litigation motions are a feature of US trial mechanisms. Then we also have pre-litigation conferences between attorneys and the parties, where they exhaustively discuss what discovery, like the evidences which would be out in the court. Suppose something they don't want in the court, they don't want to fight about it, and two parties feel, oh my god, this is not admissible, this can't come out in open, this will become a public record. All they have to do is let go of it, and they will compromise at a pre-litigation stage. Unlike in movies, if I have to say, at the last moment we don't have some evidence at the last moment to prove the case has turned at some junction somewhere. So it will be all pre-planned. We know what is going to happen, what evidences are there, what sort of line of argument would be there based on the existing evidences, based on the discovery we have made. So even this pre-litigation process facilitates the attorneys help the clients to come at a settlement, which is also very important to understand. Not every right is adjudicated and given by the court. Sometimes we can exercise our rights just by approaching rightful people and understanding those rights, and we can pre-settle it before going to the court of law. That avoids costs, time, and also the investment of emotions towards that particular relief we are seeking for. So so I would like to say, in conclusion to this particular slide, that pre-litigation and the discovery features of USA are one of the most interesting aspects, which is very useful for the parties, and also to understand what is going to happen in the court. So I will be delving more, next two slides I'll be delving more into the discovery. And in discovery, this is little clinical, but I will wrap this up very soon. In India, we cannot take everything as an evidence, and that becomes a very problematic thing in the courts. For example, we need a transcriber for a particular phone call. What is the authority? Whether the judge is allowing it, whether the particular agency and another, where is the checks and balances between one agency and the other? And not all the evidences are given by the government agencies, and often if we are um, r- uh, relying on the government agencies, we cannot get to a point that a speedy justice is delivered. There would be a chance of lot of red tapeism, or otherwise um, it is very procedure oriented when we are relying only on government agencies. So in USA that's not the case. We can always go for outside approved agencies which would validate these evidences as credible. So it's not fully under the control of the judge. Like I said in my previous slide, it is under the control of the attorney. So I'd like to discuss types of discovery. In India, the discovery is also inclusive of the deposition with the court. But when in USA, it could be a little different. We also have depositions in front of attorneys, like I said in the previous slide about pre-litigation. In that process, the attorneys will be sitting and they would be taking depositions to understand what they are admitting, what they are not admitting under an oath. So it would be also inclusive of interrogatories, and certain types of documents can be asked. When I say about documents, not even, we can, it could be anything: WhatsApp, emails, phone recordings, some app recordings. Anything can be part of the discovery in the US. Whether it is legitimate or not is the headache of the attorney to go to an agency which is approved by the court. Whereas in India, there is a lot of room to actually expedite and bring privatization for this sort of things. So I just told about pre-trial depositions, and the judge is the person who calls the shots in India in most of the cases where the evidence is decided whether it is admissible or not. In USA, it's always the attorney. And yeah, I covered this point too. Plea bargaining. So in plea bargain, what happens is, in a criminal case, one can admit that yes, I have confessed. I'm confessing to this crime. Please reduce it. I'm a changed man, and they can reduce their sentence. Often, here I would actually want to highlight about um, judicial ethics and professional etiquette of both judicial officers as well as the attorneys, especially that of attorneys. If there is a person who has committed a very heinous act, such as a rape or otherwise a child molestation or otherwise a heinous murder or a serial killer, they would advise that particular person to confess rather than going on the back and suggesting them, we'll get this evidence, we can create this, you might have a alibi somewhere, you might we can prove this way, these are the witnesses which could have, they do not sit and negotiate once they clearly know that the person is the perpetrator. And if the attorney knows, even at the cost of client privilege, he is bound by his professional etiquette to suggest him to just confess and get done with that. And that is very strongly looked after, because if there is an allegation, if the attorneys are sued, or otherwise the state feels that the attorney has compromised or the DA's office has compromised, they can be sued really bad, the lawyers. So they would never ever actually think of assisting people who are on the wrong sides of law without having any legal sanctity to it. So I feel that that's something very important, to always support the people in the rightful direction within the four walls of the law. So, plea bargaining again in India is not something very old or new, but it's something um, not very well thought of. Well, if I have to think on the top of my head, the great lawyer Ramjit Malani has taken up the case of Manu Sharma, where he has killed a woman over a brawl at a party over liquor. So t- to hear both sides of the party is, of course, the right enshrined in the constitution. Both the sides of the parties should be heard, but most importantly, whether the um, lawyer is suggesting someone to have a plea bargain and confess to the crime. I can also think of Salman Khan's case, where, you know I don't know what's the truth, but if it really happened, the plea bargain should have happened. This is not only, I mean, there is an intervention of power, because the plea bargaining is not so institutionalized, where there are judicial reliefs to that regard. If it is more streamlined and more offers are given to the people who are confessing to the crimes, at least we can put them to the justice rather than them trying to evade and go scot free at the price of power and a lot of money. That's unfair. So plea bargaining is something India has to develop, probably, with all due respect. And in civil cases, with respect to civil cases, in USA, courts are encouraged, not only courts, attorneys encourage for pre-litigation settlement between the parties, because once it goes into litigation, courts cost is exorbitantly high. So, at least 80% of the cases in civil matters actually are settled outside the court, and only to the best of my knowledge and to the best of my awareness of the case laws, only rich people could afford law in the USA in civil litigation matters. So, that is with respect to plea bargaining. And I'd like to fondly talk about my one of my favorite inspiration, Justice VR Krishna Iyer. He is for me the father of judicial activism. When we talk about judicial activism, the true meaning of it is the judicial intervention in um, accessing justice as a discourse through the courts. And this is something which can happen only when the judiciary is being proactive and looking out for dynamic changes which ought to be brought in, so that some guidelines are given to make laws to the parliament, or otherwise some guidelines are given as a precedent, so that it is followed in the next cases, and so on and so forth. So, if I would like to talk more about judicial activism even in my next slide, but here I'll give an introduction. In India, we have judicial activism as a socio-economic right. This directly links to our preamble, where social economic rights are stipulated and very well thought of, are set out in that preamble. But whereas in USA it is about individual freedom, and it is also about federalism. Suppose the a person who is from California has certain right compared to a person of Texas. So that is upholded with a lot of might compared to socio-economic right of the person, which is given by the Constitution. So this is a very different kind of thing we see in US. And individual right is given a lot of primacy compared to a person's collective right or a society's collective right. And this is in that way primarily because of the Bill of Rights, which is in the and all the 10 amendments of the US Constitution, which is specifically talking about how individual rights will be protected at every within the four walls of the law. And in India, we believe in social justice. um, um, Even the preamble talks about justice, equity, and social justice. So, our principles of judicial activism also have the underlying scope, and it takes the energy from social justice to bring out laws or otherwise a precedent which would be setting out an example for the cause of social justice. Whereas in USA, again, they want to stick to constitutional principles. They will be interpreting a constitution in strict verbatim, and state decisis. They always will be delving more into the case laws where an existing precedent is set. They do not experiment on overruling like India. They keep holding the sanctity of a precedent by the virtue of state decisis as a principle. So, in that context, we are social justice warriors, and they are individual right warriors, and they rely on constitutional principles more. And as a tool of judicial activism, we have PIL, which I'll be talking about more in the next slide. So, in PIL, PIL basically means public interest litigation. Now, what is public interest litigation? What is this public interest? Public interest is something which is having a overall effect to the public in the in any kind of domain of their life. So, for this, who has that public right to go to a court and say, yes, this is my right, but also it's everyone's right. Let's talk about it and let's actually understand what are the rights we have right now. But in India, we have the locus standi, and in plethora of cases, the Supreme Court has taken suo motu cases in the nature of a PIL to address many issues. On the top of my mind, I can think of Vishaka versus State of Rajasthan, where sexual harassment of workplace was discussed, and it is a very important case law of judicial activism. Then we can also talk about um, many cases where guidelines are given in the nature of a PIL, in the nature of a case which is in where it is in PIL. So it has a separate jurisdiction in India. There is a separate PIL jurisdiction. In fact, on a Monday, if we go to court, half of the stuff will be PILs and they'll be all mentions. So India encourages these things to happen. They want to understand what best can be done to the people. Probably I love this aspect about Indian judiciary. And in India, uh, if there is a judgment which is coming out of a PIL, it eventually becomes the law. Like Prevention of Sexual Harassment at Workplace Act 2013, it has become an act after Vishaka versus Union of India. So this has become law by the virtue of judicial activism. It eventually has to become the law in India, or otherwise it will lead to constitutional amendments, or it will lead to executive orders which are again a law, and they would be setting up certain mechanisms to dispose justice to the people. But in USA, it will only lead to intense political debate. Only in very specific sensational cases, there was a change or ratification through parliamentary action. Like, for example, the abortion laws, Roe versus Wade. Um, it has taken, I mean, it has taken a very long time for people to actually accept the case, or otherwise overrule the case, or do anything about abortion rights of the women in the USA. But India is not like that. We have PILs and we also have laws which have covered many different aspects about uh, various aspects of abortion rights in India. So ours, I believe, is very comprehensive, flexible, very. The court has that adjudicating authority to decide case on case basis. So that does not happen in USA. Like I said, it ends up in intense political discussions. And it's not even funny to say, when I had an interaction, some of my friends say America is going to have elections solely based on who is marrying who, and whether someone can have abortion rights. So that political thing is something which happens in USA, where it does not become the law, and it takes a lot of time. And for the record, women were given the voting right after nearly 2 centuries of their forming of the constitution. So it takes really a longer time to get amendments in the US. That's the problem over here. So judicial activism, yes, it happens, but how I mean, what is it doing at the end of the day in USA? I have no idea. But yes, again, there are lobbyists who would lobby for their political ideology, or lobby for their social objective towards societal change. But then again, it is the job of the lobbyists who are getting these Senate bills, but they are not taking the judicial principles into account to get a better justice system for the country. Now, I would also like to talk about my favorite justice again, who is very famous in public interest, is Justice P.N. Bhagwati. I have put out one of the famous quotes of his. I just want everyone to go through it for a bit. Meanwhile, I'll just take a small break. So, public interest. We were discussing about public interest. Am I audible?
You are audible, but that the screen is not yet shared.
Okay.
Double click it.
How about now?
No, no screen is shared, but only started screen sharing. It may take some time.
Um,
You can start talking.
Okay, okay.
how about now? How about now?
Audible, audible.
It's
You are,
audible.
you are audible. You are audible.
How about now? Can you see my screen?
No, no, not yet.
Okay, ma, okay.
No, no, screen is not shared.
Okay.
You are audible.
It is audible, madam.
Okay, thank you.
Yeah, now it's okay.
Okay. There's some problem with the window sharing. So, yeah. In public
Please
interest,
continue.
yes, I'm continuing. So, in public interest, we have in India, like I said, we have a separate jurisdiction in Supreme Court. One of the most fundamental features of high courts is we have many, many kinds of writs. Very, very, very long, unknown kind of writs exist in India, much contrary to the five writs we know. There are many kinds of writs, and the jurisdiction of high court is such that even from the colonial times it had always facilitated many kind of writs to happen, and that is something our feature. But when it comes to USA, we do not have that. There is always a person who has to be a victim of something, or otherwise someone should have a locus standi, and they have to have that personal really, really gruesome effect on their health or something to have something considered as a public interest. Whereas in India, we do not need to exactly have a locus standi to question something. When in the recent past, our chief justice, in the unfortunate case of Kolkata, when he was asking all the questions and taken it as a suo moto, and there is a discussion happening in the Supreme Court. Let us understand it is in the public interest. What is the public interest? People want to know whether the unfortunate women is being given justice in all its might, in the efficient way, in the rightful means. So this is something India has as a feature. Without having a locus standi, someone can write to the court, and also the judge can take it up on his own within his court. This is very interesting feature of an Indian court. Also the Supreme Court and the High Court, they have original jurisdiction. They can let a sumoto case, which is in the nature of a PIL, be taken into their hands, and eventually it will be very engaging, and it is also need of the hour, where the court is going into the spaces where the law does not exist. So, I didn't want to actually talk about appointment of judges, because again, I'll be also talking about executive intervention as well as legislative intervention, and everything I had to talk about it. So, but again, I thought I have set in my objectives that governance and society, how it'll be supported by the judiciary. So, in that regard, I wanted to talk about checks and balances in the context of checks and balances, where separation of power is very much exercised. In that aspect, I want to talk about appointment of judges. So, the here I'm specifically talking about Supreme Court appointments, because that's something we all know easily. In India, the Chief Justice plus four Supreme Court sitting judges give particular list of people who can be elevated to the Supreme Court That is what NJAC says, and that will be submitted to the president, and the president approves it. He doesn't withhold it or suggest something. They can discuss in closed doors what they want, but it happens. So the judiciary is doing its own collegium to elevate a person as a Supreme Court judge. Whereas in USA, it is the president who does it, and the president has the complete right to do so. He can put whoever he wants. And the fun fact about this is that they need not necessarily be qualified as an attorney to be a judge. I mean, there is no written law anywhere in the USA that who can be the Supreme Court judge in the USA. So it is a very interesting, funny thing. But fortunately, because this is a very educated country, we only have Harvard's and Yale professors or judges coming from those eminent institutions becoming the Supreme Court judges in the USA. So the president selects in the USA, then he gives it to the Congress and Senate. The Senate has to pass the bill, and they have to accept this person is a nominee for the Supreme Court, and he is approved, and he can be the president. He can be the Supreme Court justice. So this is the fundamental difference between appointment of judges in India and USA. Now, why this also is a part of checks and balances is anyone, I mean, there will be always a conflict of interest when some person is sitting as a sitting Supreme Court judge. There should not be any vested interest. He should exercise full and free will to adjudicate between the for the cases solely based on the merits, but not on personal prejudices or biases or perceptions. Yes, one may give the legal acumen and experience to some credit in writing their part of the judgment, but they cannot and should not be influenced by political lobby or the society or the media or anything as a matter of fact. So appointment of the judges is one of the most interesting and a safety valve of Indian judicial system, according to me. Like I said, it'll be full of my perceptions at some point. Okay, now I'm going to talk about a very interesting investigation I have done into both the legal systems, India and USA. So, how society participates in the judicial system, and how the justice system is not for the law abiding people only, it is for everyone. When we talk about a society, it has good, bad, the ugly. So when we talk about the justice system, again, it is inclusive of all sort of people, and they do um, be they should be participating in the justice system. How do they do it? So in USA, when there is a jury trial, there are jurors who are from the domain of teaching, domain of anything, software engineer, someone who is a retired a clerk somewhere. Anyone can be part of a jury, and they will be listening to the case without understanding the legal merits. But why are they sitting and watching? The reason is that they want to be the part of the social conscience in disposing the justice to the society. They will be the people who are not going to, they will not be the people. Let's say it is a murder case. In a closed room, all those jurors, they don't talk about this guy is lying, that guy is telling truth, this evidence is like this. That is the meritorious discussion based on existing system of the law. That they don't do. What they do is what message is need to be set out in the society, so that people will learn and understand following the legal means is the rightful way to live. So this sort of activity of jurors is a very, very interesting thing. We had in India the jury system. Unfortunately, it is done away with. We have extremely litigious and extremely very slow civil litigation and criminal litigation system in India. So the jury system, like I said, is coming through the participation of people. It is, in one way, the Vox Populi version of judicial system. And again, in the context of India, we have trial by media. What trial by media does is, in India, we don't have all this public conscience or people going to the court and asking anything in the court. We have people coming out to the media and asking questions. That's what has happened in Arushi Talwar murder case, or Sheena Bora murder case, or Sunanda Pushkar murder case. They wanted to know the truth. The media tried to get the evidence. The media tried to show the truth. The media tried to say this person is a witness, he's being hostile, he needs to be protected. Or I'm not advocating, the the media should do the trial, it will be open, fair. All I'm trying to say is, media as the fourth pillar of democracy has done a very good role in the recent past to bring light and reason for take cognizance in the courts. It has led the vision which is required from the people's conscience to participate in justice. In Nirbhaya case, again, the media has again come out. They have brought a lot of social conscience into place. They have let people speak about how they felt about it, so that the voice of the people was heard. So here again, when people are coming out in media, it is not social media stunt alone, it is also participating in the justice system to make court understand, yes, we are here. Where are the checks and balances? You need to ask right kind of questions. And I have to say, it is again under the pressure of the media and a trial by the media, who was giving all these whistleblowers, that in the unfortunate Kolkata case, Chief Justice has spoken about it and has asked all the questions which were going waves around the social media. So trial by media has its own pros and cons, but it has been very instrumental in making a justice system very inclusive of people's voices. That's what is my take on this. And another thing I wanted to talk about is sumoto action by court letters. There were a couple of letters I have written in the recent past. One of it was very significant, I believe. It was about beating up of people during the COVID times. I have written this letter in collaboration with an NGO, the then Justice, Chief Justice. I think not only me, but by me, maybe under the pressure of media, they had a PIL, and they have formed committees to look into the human right violations where people were brutally beaten up for coming out of their houses during COVID lockdowns. So beating up people is not the right way to actually deal with civilians, for as a matter of fact. So that's one thing. So everything sumoto action by the court sends a very strong message to legislature as well as the executive also. So for me, sumoto action by the court, whether it is through court letters or otherwise through NGO representation or anything, it is a very good feature of Indian judiciary. And that again, I think, is a society participation in justice system. Next, I want to talk about veteran and correctional homes in the USA. So, let's say there is a convict and he or otherwise under trial prisoner. So they will be in correctional homes and they will be looked after by a person who is from the army, retired, or otherwise person who is in the police service and retired. What these people do is they are also collaborating with the NGOs who can employ these people who are the prisoners. They will be given certain rules as to they can't leave, they have to sign every day. etc. But they can have their livelihood even though they are serving the prisoner time. There are specific areas in which they can be employed, and they will be given that right. So, veterans and do play a very good role in transforming people at correctional homes. They do give that opportunity for a prisoner to make a living out of what is lost. At least if they are changing, they're giving that opportunity. And as a matter of fact, the correctional homes are again linked to NGOs, which are again linked to city councils. So it is an ecosystem which also facilitates taking care of prisoners, also a institution. So that is something phenomenally good about USA, or I don't know, it is a feature of USA. But in India, prisoners have rights. There are a lot of ongoing trial prisoners. They may get justice, may not get justice. It's a long shot if I have to make an argument, but um, it's not fair yet in India. We need correctional forms. For example, a person with a smaller, lesser crime, let's say he has done a particular person has done a hit and run, yeah, due to excessive rain. He feels extremely guilty about it. He's still in the prison for a homicide, but still, if he has to be given a chance to work something, earn his livelihood, society should participate just like how it is done in the US. They should be accepted into professions once they are out of prisons, or when they're in prison, they should be having accessibility to education. They shouldn't be stuck to menial jobs or hard labor. They could do much better. So that's something we can learn from there. I think India has some of them, but women have that privilege of correctional facilities, but men, I'm not sure how it is done. um, Fund collections for prisoners and livelihood of prisoners. Like I said, there is a ecosystem in USA which can talk about how the life of a prisoner is going to be. And correctional homes are nothing but, quasi prison homes. People can go out of it and they can do some work. And one of the most, again, very bad and also very good feature about American justice system is they recognize mental illness, and they have separate prisons, and sometimes they don't even serve prison time. For example, all these serial killers who have all these very very bad they commit very bad crimes. They are very heinous. They have this psychotic problems. They say this particular guy is mentally sick. They get him to help, and eventually he'll plea bargain, he'll stick around, and again he will come out. uh, this is again another kind of ecosystem where the benefitors or the psychologists or the people who are working in that machinery where they're helping these serial killers. But what if this person is a person of power and taking advantage of it? Where is the checks and balances? So this is something we need to take. Let's say someone has taken a lot of drugs and has committed certain crime, then he was a minor too. There's nothing. So there are some problems with this kind of segregation and treating people with mental illnesses or addiction issues. But again, it's the ecosystem which is facilitating in USA. Probably for that one innocent person who has just done some heinous act out of social isolation or the way they were brought up. But it could also be uh, b- bad in other cases. So this is something we have to see very subjectively, case on case basis. But this is something which can be learned. um, um, uh, People with mental illnesses need to be carefully bought out and rehabilitated. um, we do have that in India, but we need to recognize many kind of mental illnesses for that reason. Not to mention identification of genders could be one of them. uh, then whistleblowers as democratic instrument. So when we talk about media, we should also talk about whistleblowers. Sometimes we don't know how justice can happen, but these whistleblowers will give that insight where we find a reason to have that judicial intervention. This is again part of society this is again intervention of society in the justice system. Whistleblowers should be encouraged, they should be bought out, and they should be protected, like Julian Assange was protected. So the society should have this open dialogue to hear uncomfortable topics, uncomfortable discussions, criticisms of all sorts, and the facilitation of whistleblowers can help the economy. Had we not have or USA not had certain kind of whistleblowers, there wouldn't be such beautiful labor laws or otherwise policies in hand with them. So whistleblowers are supposed to be is one of the instruments used in a society to in USA there is a Senate bill and people have opposition towards it. They all collectively come probably through an NGO or through a lobbyist or otherwise on their own many of the times, and they do keep telling, I don't like this, I condemn this, you can't do this, my rights like this are being violated, this is my freedom of speech, I dissent to it. And they are given time in the city council meetings to express that. Suppose there is a change happening in the city, those things are openly discussed. It is not the decision of the mayor or otherwise the person in the city council taking final decision and implementing it in an executive role. It is people's participation, their dissent, and finally the law will be taken or withdrawn with the consent of the governor. So the city council facilitates such participation. In USA, I recently had the opportunity of Senate Bill 403. I was opposing it. It was talking about certain kind of segregation in USA based on certain lines of Indian origins and etc. It was quite draconian. The verbatim was it didn't have specifics. When we don't have specifics, it takes anything on its way. So I had to condemn it, and they have heard it. And Gavin Newsom, who was the California governor, has withdrawn SB 403. For Indians in the USA, it is a big win. Because it has saved a lot of embarrassment in cultural appropriation is a very big problem sometimes. So this is one of such cases, I guess. So city councils facilitate that. That again should that is also part of justice system where the society is participating at a ground level in their organization, I mean, the city organization within the limits of the law and saying, I do not approve this, I approve this. That freedom should be facilitated. And this for me meant so much. And I would love to vouch and advocate for this in India. We were given 3 minutes time to tell our point. They were noted, they were uploaded also in the city council website. We can give our names when the particular topic is happening. Suppose the topic we want isn't happening, we can talk to one of the city council members. They will talk to rest of them, they will list out the particular topics. For example, let's say I wanted a topic of Indian education in American textbooks should not be talking about certain topics because it is not giving full picture of what it is. So I should, if I tell that and explain them, they will give. In the evening times, these city councils happen after the core, like office hours. People who work there are voluntary. They just come sit uh, and they keep talking about whether it is I will be given 1 minute or 2 minutes time. Within that time I have to tell my point, then I'll be having people for it and against it. There is no resolution, but they have taken our points. Also, the senators and Congress people, they have these phone numbers where we can call up and say, I am opposing this, I am saying this, please take my notes, this is what I want to say. You can shoot an email and they will acknowledge it. This sort of transparency and accountability is something we need to bring into India, because people's participation has been reduced to watching news channels. We have to participate in our ecosystem actively, and this is a very important thing I wanted to make on this occasion, that we need to access local government level bodies as a matter of fact, to make justice as a part of um, to bring justice through their participation in democratic process. Then we have yeah, this is something people do not exercise in India. When a bill is passed, not many know at least which website to check. If a bill is there, how to get the verbatim. So many so many crore people are there in India, and barely few thousands know which website actually gives out the bill. People do not know the changes which are happening in the bill. People do not know that they have the right to address to the parliament through the standing committee their suggestions. So this is not why are not people participating is the question. People need to question, people need to guide, people need to give their expertise, people need to tell they are stakeholders and they need to be consulted when certain law is being made. That is not the case. Probably if a bunch of bunch of NGOs may send letters to standing committees, but not every citizen is participating. When an article is written in a newspaper, it is rather seen as a very it may be taken by the standing committee or may not be. It is I mean, political discussions are so huge without having to talk about public participation. This is again in a legislative process too. Society should be a part of the justice system. That this can happen when we are able to dissent, or otherwise encourage, discourage, or talk about the stakeholders in making inclusive decisions. So writing to the parliament in India is something I would like people to be encouraged about. When I talk about city councils, I told about how internet and everything they are using, as well as how free and accessible it is, and how it does not deter the timings of the people. It's in the evening time. So uh, the same thing, if you look at parliament, we have to write, we need to be aware, we need to see whether verbatim is correct or not, how many private member bills we have as proposed by the people in general interest. That's one thing we might want to actually look upon. So we need to have parliamentary suggestions, people writing to the parliament and the standing committees to bring out things. So in USA, we have lobbies and NGOs who encourage people to have the knowledge, people to be enlightened, people to understand what are the democratic resolutions they have to their problems. And these people are very instrumental in bringing about the change in the society, be it abortion laws, be it same sex marriages, be it child related rights, any sort of thing. Lobbyists and NGOs are in the forefront of US democratic ecosystem. So I do not want to say lobbies do a good job in USA or NGOs do a good job, but the very fact that they exist as an instrumentality as an instrument to voice out public opinion is the takeaway. We need to have that access and that transparency and the vision from the lobbies and NGOs to bring about social change through their um, participation in judicial as well as legislative actions. And in USA, we have case workers and social workers. Suppose if we go to a community hospital where the prices are low, no one has an insurance, the person is undocumented in the USA, social workers will help them out. So a certain person is so poor, they are like homeless, social workers will help them out. In San Francisco, we have a lot of homeless people. They are being taken care by case workers and social workers, so that although they are druggists, they are addicted, they are helped out with their health needs. And if someone is not a drug addict but a homeless person, social security benefits, how do they know they can access this? So social workers come into picture. These are all people who are either with the NGOs or the lobby or anywhere. They are still attached to the government. They're being part of the social change. They are being part of the democratic discourse through their ground level work. So these people are very much encouraged. I feel that India has a lot of learning which can do with caseworkers and social workers. There are many people walking into government hospitals, and no one will be there to tell them, you go to this place, you go to that place. Everyone is asking everybody where to go, what to do. It is totally unfair. There is lot of paperwork. The paperwork needs to be done by someone. There is a disparity of education. Someone might be blind, someone will be not able to write. They can't bring their own. Where is the diversity and inclusion in social spaces? Although our government hospitals are efficient, we also need to have these social workers and case workers to work case on case basis, so that uh, they bring out social justice overall. They bring that equity, they bring that balance. So these are some perceptions and observations I have done by myself solely, and these are my thoughts alone. And I pondered upon these things more, because I felt it's high time both the countries learned from each other. So these are my very important notes I have made and understood through my very limited experience in life, I guess. Then I want to also talk about culture as an inclusive part of law. When I talk about culture as an inclusive part of law, it is not religious right. It is not any other right. It is a collective right of people to have that cultural heritage, to have that knowledge, traditional knowledge recognized, folklores recognized, their arts and their society being recognized for its cultural heritage. These are the rights. So in these rights, uh, somehow law, we are very colonial in approach. For us, civil marriage is a marriage. Mm, which is approved by the court. Obviously, it should have legal sanctity. Um, all these, there are societies in India where multiple partners are there. It is not uh, uh, understood that it is a part of that society. Rather, what we are doing is we are trying to make them into monogamous. I'm not saying it is good or bad. I'm not going into the merits of having such a structure. I'm only trying to say, where is the protection of indigenous right of such people from certain culture. So this is important. Maybe if we want to be done away with dark very hostile practices, like we had sati, apartheid, all these things. We have come out of it. They were social evils. But when privacy, right to life with personal liberties involved, cultural right as a collective right for indigenous people or people of certain cultural distinction should be particularly recognized. Th- this is one thing I'm sitting on and thinking sometimes, why cultural collective rights do not exist in India. So these cultural rights can be tangible, they can be intangible, they can be in the form of language, in the form of anything. These have to be protected by law as well as judiciary. So this is one point I wanted to moot, not only in USA but also in India. both the countries have failed to recognize culture or tradition as a part of law, although the sources were taken from them. They haven't done justice enough to recognize the diversity and inclusion aspect of it. Next, I'm reaching to the conclusion of this particular presentation. I'm going to just overall, give conclusion to what we can learn from them. They can learn from us. In USA, the USA, what can USA learn from Indian judicial system? Like I said, the PIL system in India is social justice centric, and that's something these guys can learn. Instead of individual freedoms, they can also talk about social justice, and they need not delve into the constitutional aspects of it. They can still continue to have social justice without having to enter into the spaces of going into excessive legal battles. And next is judicial accountability. And Jack, like I discussed, the president in USA will give the Supreme Court elevation, whereas in India, Supreme Court judges, four of them, plus the Chief Justice gives the suggestion who can be the Supreme Court Justice. This is much better. Then we have fast track courts. In India, fast track courts, especially if I have to give an example, commercial courts have done phenomenally well in India. And I would uh, think, okay, in USA, one might actually think the justice is really speedy and fast. At the time of discovery, if attorneys are mixing well together, it goes a very long way. And if it's high profile, it'll go even longer. So fast track courts in India, like I said, in commercial courts, they're very fast. And if it is adjudicate, the case is apportioned to a fast track court, the justice is delivered really fast. And what else USA can learn from India? The lower level, like the Khap panchayats or panchayati meetings. Um, these are lower level of judiciary mechanisms. They need not necessarily have any sanctity through law. They are not even quasi judicial. But this judiciary at a lower level involves people participating in democratic discourse, which is very essential and important part of democratic discourse. So in USA, we do not have that aspect. Lower level participation through non-judicial or quasi-judicial bodies, but we do have attorneys speaking to each other. That is different from this. So from India, if we have to learn, what the Panchayati Raj system talks about this. It's not justice in mother tongue; it's judgment in mother tongue. So entire land of America, we had Indians. They call them Native Indians. They had their language was different. Now they don't have it in their mother tongue. They have it in English, probably due to colonization. Spanish. The judgment can be in Spanish. The language of court can be in Spanish. That is not so inclusive there. So that's one thing. In India, we have that. We have judgments which are translated to Telugu or Orissa or Kannada, and many of the court documents, especially at a trial level as well as the FIR, they are often in the mother tongue, giving a clarity and access to the people who are the stakeholders. Curative and judicial activism. If I have to tell about curative petitions, it simply means that all the facts of the case are taken away from the case, and only the legal aspect of it in a particular manner is discussed. So, in a curative petition, when we take out all the facts and go for the only legal discussion and the legal merits of it in depth, one word by word using um, um, interpretation of statutes, it leads to something. And curative petitions are not are the highest level in an apex court to give a it's the last door to knock for justice. So this is a very good thing in India. Even for Afzal Guru, I believe at the last no, Yaqub Memon, yeah, Afzal Guru or Yaqub Memon, in both of their cases, I believe curative petitions were there for not letting them be hanged. So that's very interesting thing about Indian judicial system. We will have that opportunity to have that curative petition at the up, an appeal to an appeal in the apex court. And judicial activism in India, thanks to Justice P.N. Bhagwati and V.R. Krishnaiyer, they have set a precedent to the world. They have become the visionaries to follow how judicial activism and intervention can take forward the social conscience of the people with the changing times and to advocate for dynamicness. And now this is the end, the probably last slide. What can Indian judicial system learn from USA? In Indian judicial system, we have to learn from USA judicial independence. By that, I don't talk about appointment of judges. I want to talk about professional etiquette. The judge is so careful in the court. The attorneys are careful. This is due to the fact that they have to pass rigorous examinations of professional responsibility. The judge does not overstep or over ask. They do not be unprofessional. They do not ask. They do not, in fact, be funny also. They are just sitting there being very focused on what is the work. There is no sense of exchanges or personal privileges in US judiciary. If there is an iota of doubt, it can be opening Pandora box of problems both for the attorney and the judge. So judicial independence is something we can learn from USA. Then alternative dispute resolution mechanisms, mediation or anything. I mean, when I say ADR, I also talk about pre-litigation process and the compromises which can happen. In USA, at least 80% of the cases do not go to trial. They are settled. Settlement is good. So that we can learn. Look, I mean, with the number of cases, I would rather have our own separate judiciary just to adjudicate, you know, small cases where, settlement can happen. Then use of technology. Like I said, US courts have everything as a public document very much out there in open. The some person wants to have, yeah, even the track record of a judge, even the track record of a attorney is there out. If they have a disciplinary issue, that is highlighted over there. If they had something, that is highlighted, everything is recorded. Even in the matters of proceedings, you want to file something, it can be filed online, you can appear online. Everything can be done online. The accountability which was bought through technology in just judicial system of USA is nothing short of uh, commendable work. It is so good. They are bringing lot of accountability through technology. In India, we do have technology being used. Probably it can improve. Um, uh, in terms of capacity building, in terms of handling things, all these things needs to be done. Next, I want to talk about public participation in justice. I have clearly set out all of these in my previous slide. So people have to participate in various forms, in the interest of justice. Prisoner reforms, I have spoken about it. Prisoners have to be dealt in certain way. Then lawyers' professional responsibility. I want to talk about a case where I wanted to sue this public transport people for enormous delay of 8 hours. So none of the people, like attorneys over here, I called up, were taking the case, and they were saying, "I'm not specialized in that. I'm not supposed to take it." In India, people, attorneys, I mean lawyers, they want to jump in and take the case without having specialization or understanding. Sometimes learning things on their own and experimenting with our lives. But in US, they don't do that. And whatever the suggestion they are
Well done
giving, they
there.
write. Hmm?
Thank you.
Yes. Excuse me. Can you see my screen?
Yeah, both we can see.
Yeah. So professional responsibility is very much meticulously put out, and there is one exam which I'm writing. It's called multi-state professional responsibility. It has 80 marks, 50 questions. Out of 50 questions, 40 questions have marks, and 10 questions do not have marks. And I don't know those 10 questions, and I have to get a percentile which is above 85% to qualify in professional responsibility. So it is a very tough exam, and we have to be very thorough. We need to understand attorney client privilege, when to break, what to record, what not to record, everything has to be, it is so well sought. It is so clear. And thanks to American way of legal system, it is so easy to even read and understand. Sometimes we don't understand what is there in Indian law. It is full of jargons. Sometimes dictionary themselves, wonder why it is so hard. Even ChatGPT can't comprehend some laws in India. So it can be easier. It can be straightforward. It can be descriptive in a very less easier English, or probably their own mother tongue. So this professional responsibility aspect is a very good thing, both for the judges as well as the lawyers, which we need to learn from the USA. And the verbatim I just talked about it. It has to be simpler. So the way forward, I want to see how countries need to grow. A civilization is always judged by the judiciary and people conscience which is awakened through the judiciary, for me. So when we talk about a civilization in 21st century, which is a global civilization, a global village, there are a lot of changes which are happening. And this, in an era of dynamic changes every day, there is a lot of scope for law to come into place, and people need to adapt to those laws, and they need to be aware of their rights, and they need to be part of that democratic discourse. If they are not able to do so, it will eventually be a failed civilization. The purpose of law is not only to bring law and order, social justice, but also to understand with the changing times. It has to change itself to fit the civilizational goals to exist together. So, we are living in a global era where we have data collection agencies, we have international branches guiding us what to do, we have happiness indexes, we have many more indexes. All these speak about many things of human aspects, and all of these things are not actually pondered upon by judges. So when we are talking about criminal justice, we are only stuck at actus reus non facit mincit rea. It's just intention, stages of crime. We need to talk many aspects of it. The adaptation to changing times is very important. Mental illnesses are very common. How do we be inclusive and change people through justice as a mechanism is one thing I was always thinking about. New challenges require new solutions. Legislators need to be dynamic, and they need to be very quick. Justice does not mean it is coming through the law. Justice can also come through people's participation in seeking a democratic discourse. So it comes in a very different way to each and everything. So we legislators have their role, executive can also do it, and there are many ways to attain justice in that format. And finally, we need to have justice very speedy, and it needs to be cost effective. I mean, justice is one thing which should not have a price. It should be free. accessible to everyone, even the most affected person and person who cannot have it, any disabled person, someone who can't hear, see, talk, even that person should be able to come up and say, yes, I need justice. And that level of inclusion in a utopian world is something what I see. With this, I want to talk about uh, um, my a guiding principle for me, always I cherished. I want to read out. With this, I'll close my speech. A very long word. Thank you for being patient. My It is Where the Mind is Without Fear by Rabindranath Tagore. This is something I read often, and it inspires me to understand why and what kind of law and justice should be in the society. So, where the mind is without fear. Where the mind is without fear and the head is held high, where knowledge is free, where world has not been broken up into fragments by narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habit, where the mind is led forward by thee into ever widening thought and direction, into the heaven of freedom. My Father, let my country awake. Thank you.
Thank you, Malavika. You have done a wonderful job. It's in fact a very vast subject. I know pretty well that in 1.5 hours is insufficient to have a comprehensive look about it. And you have started almost from the appointment of judges, trial, jury, and the pre-trial methods and discovery of evidence, every aspect of the legal systems you have compared. And you have also talked about the media intervention and the intervention of the society and the public participation in the legal system. It's a wonderful presentation, and we have no words even to praise you. But sometimes, because of the vastness of the subject, I would like to, as far as today is concerned, normally we allow uh, all the people to have a question and answer from you, but because of the session going a bit lengthy and the subject matter being a very serious one, because America is an advanced democracy, whereas we are still struggling to come up to a certain level of democracy. And the population, we have almost 100 cases per each judge in India, each judge will be tackling on average 100 cases per day. And American judges will be hardly tackling about 3 or 4 cases per day. And I know the number of, if you take 1,000 population and compare with the American legal system and Indian legal system also, there will be terrible, difference of things. And unfortunately, the Grama Nyayalas, which were proposed to be incorporated into the Indian legal system, it could not take off. Otherwise, a lot of load would have come out of the courts. Only 10 states in the entire India have accepted it. They have established about 457 Gram Nyayalayas, out of which only 257 are functioning in the entire India. You can just imagine actually that act is almost made defunct in India. So because of that, the trial courts are having a lot of load, and the judicial system, the system of justice, is suffering a lot. It's also a fact. But at the same time, right from the beginning, Ambedkar, in the course of Constituent Assembly debates also, when people have insisted upon the Panchayat Raj system, Panchayat Raj court, Panchayat courts, Gram Nyayalayas, Ambedkar was a bit hesitant about it, because this system, which has suppressed certain sections of the people over thousands of years, if the judicial powers are also given to the Gram Panchayats, it is likely to be a terrible situation for those oppressed sections. So Ambedkar was very conscious. He wanted to have a modern legal system, trained judges, and the judges appointed on the basis of written tests and interviews, so that delivery system of justice shall be very strong and modern. This was the idea before Dr. Ambedkar ji. So once again, thanking you very much for your wonderful presentation. I request for today, please condone me for my adventure. I seek only a few responses from senior most persons available here. Instead of searching for everybody, if time is still available, I will keep it open. Now I ask Professor Balmohan Das to make a few observations very shortly, so that we can think of all others to participate in this session.
రవికుమార్ గారు మాలవిక నందివెలుగు వారి అమ్మాయే కదా?
నేను ఇప్పటిదాకా సీక్రెట్ గా పెట్టాను, మేము ఎవరు చెప్పాలి?
మీరు పెడితే మాకు తెలియదు ఏమిటి?
కాదండి కాదండి, కాదు 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 కాదు,
సో
అసలు కాదు.
ఇన్నాళ్ళు అమెరికా అంటే సాఫ్ట్వేర్ ప్రొఫెషనల్స్, డాక్టర్లు అనుకుంటాము. మా ముక్తేశ్వరరావు గారు లా వాళ్ళను కూడా అమెరికాలో ఫేమస్ చేశారు. ఐ థింక్ మాలవిక ఇన్హెరిటెడ్ all positive qualities of father, gentleness, clarity of thought, and excellent expression. ఇంకా ఉన్నాయి, టైం లేదు కాబట్టి నేను చెప్తున్నాను. మాలవిక గారు చాలా చక్కగా చేసావమ్మా. నేను టీచర్ని కాబట్టి మీరు కామెంట్స్ నేను మిగతా వాటికి ఇవ్వదలుచుకోలేదు, కానీ మీరు మా రవికుమార్ గారు ఏదో పిలిచారు, నాన్నగారు కూడా చెప్పారు అని మాకు చాలా మంచి విషయాలు చెప్పారు. మీరు దయచేసి ఇంతటితో వదిలేయకండి దీన్ని. ఇదే టాపిక్ మీద మీరు పిహెచ్డి చేయండి. అది ఇండియాలో సబ్మిట్ చేస్తారా, అమెరికాలో సబ్మిట్ చేస్తారా, మీ ఇష్టం. బట్ షూర్గా మీకు పిహెచ్డి కాకుండా ఆ థీసిస్ వలన ఇండియాకి అటు అమెరికాకి రెండు దేశాల లీగల్ సిస్టమ్కి చాలా బెనిఫిట్ అవుతుందని నా ఉద్దేశం. మాకు ఆంధ్ర యూనివర్సిటీలో లా ప్రొఫెసర్ ఒక ఆయన ఉండేవారు, ఇప్పుడు లేరు ఆయన, ప్రొఫెసర్ గుప్తేశ్వర్ గారు. ఆయన పెండేకంటి వెంకట సుబ్బయ్య, మీరు అక్కడే చదివారంటున్నారు. అక్కడ కొంతకాలం రిటైర్ అయిన తర్వాత కొంతకాలం ఉన్నారు, తర్వాత అమెరికా వచ్చారు, పోయారు. ఆయన ఎప్పుడు చెప్పేవాడు, లా యూనివర్సిటీలో లా ప్రొఫెసర్స్, యూనివర్సిటీలో లా ప్రొఫెసర్లని కోర్టుకి ఎందుకు ప్రాక్టీస్ రానివ్వరు ఇండియాలో. ఆయన ఫైట్ చేశాడు. ఆయన పెద్ద ఆర్టికల్ కూడా రాశాడు, నాకు కూడా పంపించాడు ఆర్టికల్. సో మీరు చేసే దాంట్లో ఈ ప్రజల్ని, సిటీ కౌన్సిల్ని, ఎన్జిఓస్ చేసేటట్లుగా లా ప్రొఫెసర్స్ ఒక అడ్వైజరీ కమిటీ ఎందుకు వేయరు కోర్టుల్లో, నాకైతే అర్థం కాదు. I think I request you to do this definitely. An excellent topic that has enlightened all of us. Supreme Court లో ఈ రోజున 2024 లేటెస్ట్ 80,221 కేసులు పెండింగ్ అంట. ఇది మన న్యాయ వ్యవస్థ. అన్ఫార్చునేట్ గా 100 కేసులు రోజుకు చేసినా కూడా జరగని పరిస్థితి. లెట్ us learn from America and America also learn from India. Thank you, Amma.
Thank you so much. Really means a lot. Thank you.
Janardhan Reddy garu, I request your intervention.
Yeah, thank you, sir. First time Mukteshrao Garu has been telling about this discourse that is happening every Friday. And a couple of times he also shared the link, but I could not join. And I hope so henceforth I would also be part of your think tank. And Malavika, hearty congratulations. Great presentation. So you were not at all perturbed, like a very smooth flowing stream of water. And there were no ups and downs, no disturbances. And there was no whatever sort of, disturbance in the entire presentation. Your presentation was really nice. But one thing I was looking at was the quantitative analysis, like 5 crore cases are pending in India roughly. And actually, I studied this in around 1983 in India today, that at that point of time, 3 crore cases were pending in all the courts in India. And it would take around 326 years if no further cases are filed. So that gets updated now and then. Now, to be precise, around 4 crore 86 lakh cases are so pending, around 80,000 or so in Supreme Court, etc. So in US system, how fast is the average? Is there any quantification, like how fast is the judicial system giving the final verdicts, how long it will take, and whether we can emulate. Okay, as Dr. Ambedkar felt, that was also true, that if Nyaya Panchayats without professional competency and without governmental system, if the power is given, but certain powers could have been given. Somebody calling somebody other by name, abusing some boundary disputes, etc., which do not require any constitutional interpretation. But many problems are there in the many villages, many neighborhoods, etc., and it is not accessible. It is costly, and delivery we cannot express in our lifetime. So Indians, whatever, it is not the fault of the judiciary system, but our political, whatever our system, it is not delivering. So as expected. So either Raghu Kumar or somebody else can tell, since it is a right question, like what is the quantum of load that is pending on the judiciary system of USA. Once again, congratulations, Malavika. So you have grown up well, evolved well, and your presentation was so nice. So there was never a point where we could have obstructed you or stopped you. Thank you.
Thank you, sir. Thank you. Dr.
Thank you so
Muralidhar
much,
garu.
uncle.
Dr. Muralidhar garu.
Good evening, sir. Nice
I want to make
presentation.
it as a jury because jury, we don't have jury system. Now I am calling a doctor, IAS officers, then a teacher, then everybody, so that it becomes a jury.
Really wonderful presentation, Malavika. ఈ ఇండియన్ జ్యుడిషియరీ సిస్టమ్ లో జరుగుతున్నటువంటి డిలేస్ కానీ ఇవన్నీ కూడా చూస్తున్నప్పుడు పైనుంచి కింది వరకు నాకు కోపం వస్తూ ఉంటది. చీఫ్ జస్టిస్ దగ్గర నుంచి మన రఘుకుమార్ గారి వరకు అందరి మీద నాకు కోపం వస్తూ ఉంటది. అప్పుడు నాకు అనిపించేది అమెరికాలో కూడా ఇట్లనే ఉంటదా అనేది అప్పుడప్పుడు నాకు వస్తున్నటువంటి డౌట్లని మీరు చాలా చక్కగా క్లారిఫై చేసినారు. థ్యాంక్ యూ వెరీ మచ్. ఇట్ ఇస్ రియల్లీ ఎ వండర్ఫుల్ టాక్. ఇట్ ఇస్ రియల్లీ an enlightening talk. Thank you very much.
డాక్టర్ కాళిదాస్ పురుషోత్తం గారు. డాక్టర్ కాళిదాస్ పురుషోత్తం గారు.
నమస్కారం అండి.
నమస్తే సార్. నమస్తే.
హలో,
చెప్పండి సార్, ప్లీజ్ మాట్లాడండి.
శ్రీమతి మాళవిక గారి ఈరోజు ప్రజెంటేషన్ చాలా బాగుందండి. నేను పెద్దగా అంత సీరియస్ గా పట్టించుకోలేదు కాబట్టి చాలా బాగుంది. తర్వాత మన న్యాయ వ్యవస్థకు యుఎస్ లో ఉన్న న్యాయ వ్యవస్థకు చాలా పోలికలు తేడా చెప్పారు. నేను ఆమె ఒకసారి 1-2 ప్రశ్నలు అడగాలనుకుంటున్నాను. అందులో ఒకటి ఏంటంటే 2002లో నాకు గుర్తులేదు డేట్, న్యూయార్క్ సిటీ మీద బాంబ్ చేసినప్పుడు కొన్ని దేశాల నుంచి పట్టుకొచ్చారు. వాళ్ళు పెద్దవాళ్ళు అయ్యారు, 35-40 ఏళ్ళు అయ్యారు. వాళ్ళు ఇంకా క్యూబా పక్కన ఒక ఏదో మర్చిపోయాను నేను ఇప్పుడు, ఐలాండ్ గా అమెరికా స్వాధీనం దానిలో పెట్టున్నారు. యాంటనామాలో పెట్టున్నారు. వాళ్ళకి ఏ హక్కులు లేవు. వాళ్ళు అలాగే నిరాధారంగా ఉన్నారు. నేను వాళ్ళ గురించి చాలా చదివాను. మేము పెద్ద ప్రపంచానికంతా వెలుగు చూపిస్తాం అనుకునేటటువంటి అమెరికా ఇదేనా వ్యక్తుల వాళ్ళ జీవితాలను ధ్వంసం చేయడమేనా మిమ్మల్ని అడుగుతున్నాను. మీకేమైనా వివరాలు ఉంటే చెప్పండి.
Thank you, sir. Malavika, please wait till the end so that we can have all the questions together. Hemant garu, unmute చేయండి సార్. హేమంత్ గారు అన్మ్యూట్ చేసుకోండి. అన్మ్యూట్ అవ్వండి హేమంత్ గారు. అన్మ్యూట్ అవ్వండి సార్. అన్మ్యూట్ అవ్వండి. అవ్వలేదు ఇంకా. అన్మ్యూట్ అవ్వలేదు సార్ హేమంత్ గారు. ప్లీజ్.
Okay, sir.
Yes.
Sir, I'm Hemant. Malavika was my colleague in CVR English News Channel, and I worked for more than a decade in CVR English News as a associate editor and editor. She was a wonderful person, and I'm amazed by the kind of lecture she gave with very good exposure. Not a single word. When editor's job is to remove the words which are irrelevant, so not a single word goes waste. Entire her presentation was so awesome, and I have 2 questions for her. First, with the advent of sociological changes and a lot of cultural changes happening across globe, including US, and comparing US with India, like and how judicial system and how the constitution can be reformed, with the changes taking place in sociology as well as cultural ethos.
Thank you, sir. Thank you very much. Tirumala Shetty Nageshwar garu, you are in America. Tirumala Shetty Nageshwar garu.
నమస్తేనండి. మాళవిక గారు, వందనాలు. మీ ప్రెజెంటేషన్ చాలా బాగా ఉంది. నేను కూడా అమెరికాలో 51 సంవత్సరాలుగా ఉన్నాను. కాబట్టి ఇండియా గురించిన అవగాహన కంటే ఇక్కడ ఎక్స్పోజర్ ఎక్కువ అనుకోవచ్చు కదా. అలాగే చూసుకుంటూ ఉంటే రెండిట్లోనూ గ్రేట్ ఐటమ్స్ ఉన్నాయి, రెండిట్లో కూడా రూపాలు ఉన్నాయి. ఇప్పుడు గ్వాంటానమో వ్యవహారం కానీ ఇంకా ఎన్నో రకాలుగా విన్నాము, చూసాము. ఒకటి ఏంటంటే, హౌ ఆర్ వి ఎడ్యుకేటింగ్ అవర్ సిటిజన్స్ ఇన్ ఇండియా? వాళ్ళకి ఫండమెంటల్ రైట్స్ గురించి కానీ అవగాహన ఏముంది, న్యాయం కోసం ఎలా చేయొచ్చు, ఎన్నెన్ని రంగాల్లో తోడ్పడుతుంది ఈ విషయ పరిజ్ఞానం కోసం అనేది ల్యాకింగ్ అనిపిస్తుంటుంది. తర్వాత బికాస్ ఆఫ్ ఇగ్నోరెన్స్ పీపుల్ గివ్ లైక్ హ్యాండ్స్ అప్, వీ కెన్ డూ నథింగ్. ఒకవేళ నేను ఇండియా వచ్చినప్పుడు కొన్ని విధాలుగా పరిశీలించి కొన్ని విషయాల గురించి మాట్లాడుతూ ఉంటే ఇక్కడ జరగని పనిలే ఇట్లా ఈ డిస్కరేజ్మెంట్ ఎక్కువగా అనిపిస్తుంటుంది. బట్ ఇన్ ఎనీ కేస్, without taking too much time, I would say also thank you so much for reciting the poem. నాకు అది దాదాపు రోజు అదే గుర్తు వస్తుంటుంది, ఎస్పెషల్లీ ది లాస్ట్ పార్ట్ ఆఫ్ ఇట్. Congratulations and thank you so much.
Thank you, sir.
Thank
can
you.
I have the response of Swarnalata ji? Swarnalata garu.
సార్ నమస్తే. మాళవిక, కంగ్రాచులేషన్స్. చాలా ఎక్సలెంట్ టాక్ ఇవాళ. నాకైతే అసలు నాకు జుడిషియరీ మీద పెద్ద ఐడియా లేకపోయినా ఆద్యంతం కూడా ఆసక్తికరంగా చెప్పావు. మొత్తం చెప్పడం స్టార్టింగ్ నుంచి కూడా అసలు వింటుంటే అసలు ఇక్కడ బోర్ కొట్టలేదు. ఏం జరుగుతుంది నెక్స్ట్, ఎలా కంపేర్ చేస్తున్నావు అని మంచి ఒక రీసెర్చ్ ఓరియంటెడ్ పేపర్ లాగా ప్రెజెంట్ చేసావు. నాకైతే లా స్టూడెంట్స్ అందరూ కూడా నీ టాక్ వినాలి. ఈ రోజు నువ్వు ఇచ్చిన టాక్ అయితే లా స్టూడెంట్స్ అందరికి కూడా ఉపయోగపడుతుందని అనిపించింది. మంచి అనాలిసిస్ చేసావు నాన్న. ఇవాళ చాలా ఎక్సలెంట్, బాగుంది. కంగ్రాచులేషన్స్ వన్స్ అగైన్.
Thank you, aunty.
కాసర్ల రంగారావు గారు. కాసర్ల రంగారావు గారు. Malavika, remember you have the interventions of senior academicians like Professor V. Balmohan Das, then a medical doctor like Dr. Muralidhar, then teachers, then IAS officers, all this is a retired professor of Telugu. So what is exactly, this is jury which is conducting a trial on you.
I feel like that mockingbird.
In the initial days, trial was in the jury. People used to include even tailors, cobblers. That was happening in England, Europe, even America for a long time. Now, can I have the intervention of Gurumurthy garu? Gurumurthy garu.
Yes, sir. Good evening to all, sir.
Yes, sir. Please.
అందరికీ నమస్కారం అండి. ఈ రోజు మేడం మాళవిక గారు ఇచ్చినటువంటి ఉపన్యాసం ఏదైతే ఉందో, అంటే ఈ రెండు న్యాయ వ్యవస్థల్ని పోల్చుతూ వారు ఇచ్చినటువంటి ఉపన్యాసం అమోఘంగా ఉంది. ఒకటి. రెండవది ఏంటంటే, వారి స్ట్రీమ్ ఆఫ్ థాట్ ను కూడా నేను కొంచెం తెలుసుకోగలిగాను. చాలా ప్రోగ్రెసివ్ గా ఉంది, చాలా అనలిటికల్ గా ఉంది, సింథసిస్ కూడా చేయగలిగారు. సో ఇంకొకటి ఏంటంటే, నాకు అనిపిస్తుంది ఈ లా గురించి ఎక్కువ విషయాలు మాట్లాడే కంటే నా తరపున నేను చెప్పేది ఏంటంటే, ప్రపంచవ్యాప్తంగా కూడా అండర్ ట్రయల్స్ ఉన్నారు. ప్రపంచవ్యాప్తంగా అండర్ ట్రయల్స్ యొక్క ఒకవేళ దాని యొక్క ఎంతమంది ఉన్నారనేటువంటిది ఒక క్వాంటిటేటివ్గా మనం కనుక్కుంటే నిజంగా చాలా ఘోరమైనటువంటి పరిస్థితి ఇప్పటికీ ప్రపంచవ్యాప్తంగా ఉంది. అది రాజకీయ పరంగా కావచ్చు, ఆర్థికంగా కావచ్చు, లేక దొంగతనాల వల్ల కావచ్చు, దోపిడీ వల్ల కావచ్చు, ఇంకా ఇతర అనేక రకాలు ఉన్నాయి కదా, అవన్నీ దుష్ట వ్యవస్థల వల్ల కావచ్చు. మొత్తానికి అండర్ ట్రయల్స్ చాలా ఉన్నాయి. మనకు జడ్జిమెంట్స్ ఎంత ముఖ్యమో యాక్షన్ ఓరియంటెడ్ ప్రోగ్రామ్స్ ఈ లా డిపార్ట్మెంట్ లో జరగాలి. జడ్జిమెంట్స్ ఖచ్చితంగా రావాల్సిందే, లేట్ కావద్దు అనేటువంటిది ఎంత ముఖ్యమో ఆన్ స్పాట్ పరిష్కరించేటువంటి సమస్యల్ని కూడా పరిష్కరించలేకపోతున్నాము. నాకు అమెరికా గురించి అంతగా తెలియదు, కానీ నిజంగా అండర్ ట్రయల్స్ ని ఖచ్చితంగా దాన్ని మీరు థీసిస్ గా తీసుకొని అండర్ ట్రయల్స్ ఇవాళ ఎంత ఉన్నారంటే అసలు లెక్కలేనన్ని ఉన్నారు. వాళ్ళ యొక్క జీవితాల గురించి నిజంగా చాలా వరకు ప్రపంచానికి తెలియాల్సినటువంటి అవసరం ఉంది. ఒక్కొక్కరిది ఒక్కొక్క గాథ అవుతుంది, ఒక్కొక్కరిది ఒక నవల అవుతుంది, ఒక్కొక్కరిది ఒక సంచలనమైనటువంటి గ్రంథం అవుతుంది రాస్తే. అంతమంది ఉన్నారు. ఆ విషయం మీద తమ దృష్టి కేంద్రీకరించాలని నేను విజ్ఞప్తి చేస్తూ, ఇక నేను ఒక చిన్న ప్రయత్నం చేశాను. మిచిగాన్ యూనివర్సిటీలో నేను వెబ్ సిరీస్ కి సినిమాకి రాశాను. నేను రాసినప్పుడు అప్పుడు నాకు కారణం ఏంటంటే నేను స్టూడెంట్ని, మిచిగాన్ యూనివర్సిటీ డిస్టెన్స్ స్టూడెంట్ని. అందులో నేను ఒక 11 ఎపిసోడ్స్ రాశాను. నా హీరో లాయరే. ఆయన లాయర్, ఆయన లా స్టూడెంట్ అప్పుడే అతనికి ఉన్నటువంటి ఫ్రెండ్స్ అంతా కూడా అన్లాఫుల్ యాక్టివిటీస్ లో పాల్గొనేది. అతను ఒక్కడు మాత్రమే లాయర్ అన్నట్టుగానే ఉండేవాడు. అతని జీవితంలో కూడా అతను లా యాక్టివిటీస్ ని ప్రోత్సహిస్తూ ఉండేవాడు స్టూడెంట్ లైఫ్ లో. సో అట్లాంటి వ్యక్తి వాళ్ళందరి మీద యాక్షన్ తీసుకోవడానికి అతను ఎంత ఒక క్రూడ్గా వెళ్లాల్సి వచ్చింది. తర్వాత వాళ్ళందరినీ మార్చి తను ఎట్లా లైఫ్ ని బాగు చేశాడు వాళ్ళందరినీ. అలాగే విక్టిమ్స్ ని కూడా, విక్టిమ్ ఇక్కడ హీరోయిన్, ఆ విక్టిమ్ ని కూడా తను ఎట్లా పైకి తీసుకొచ్చాడు, ఆమెను కూడా చదివించి మళ్ళా తన యొక్క జీవిత నేస్తంగా చేసుకోవడం జరిగింది. సో ఈ స్టోరీస్ మీద నేను రాయడం జరిగింది. అది నాకు అమెరికా సిచ్యువేషన్ లో రాశాను, కానీ న్యాయ వ్యవస్థ గురించి ఎక్కువగా అందులో చేర్చలేదు. దయచేసి నేను చెప్పిన విషయం మరొకసారి గుర్తు చేసుకోండి. అండర్ ట్రయల్స్ ప్రపంచవ్యాప్తంగా చాలా దేశాల్లో ఉన్నారు. ఈ యొక్క అమెరికానే కాదు, అన్ని దేశాల్లో ఉన్నారు. కాబట్టి ఎట్లాగో కమ్యూనిస్ట్ దేశాలు అనుకున్నటువంటి వాటిలో నుంచి మనకు ఇన్ఫర్మేషన్ రాకపోవచ్చు. వచ్చినటువంటి ఇన్ఫర్మేషన్ ని మనం క్రోడీకరించితే కొంత మేలవుతుంది. దానివల్ల కనీసం వాళ్ళు తాము చేస్తున్నటువంటి దుష్ట వ్యవస్థలను అడ్డుకునే పరిస్థితి లేనటువంటి గవర్నమెంట్స్ కు ఒక చెంపపెట్టులాగా ఉంటుందని చెప్పి అభిప్రాయపడుతూ సెలవు తీసుకుంటున్నా. గో హెడ్ మేడం.
థ్యాంక్ యూ సార్. థ్యాంక్ యూ. కేజే రామారావు గారు.
థ్యాంక్ యూ.
కేజే రామారావు గారు. మేడం.
సార్ నమస్కారం సార్. మాళవిక గారు చాలా అద్భుతంగా ప్రజెంట్ చేశారు. నాకు ఎప్పటికీ చాలా ఆసక్తి ఉంది జ్యుడిషియల్ యాక్టివిజం మీద, అమెరికాను ఇండియాకు సంబంధించి తెలుసుకుందామని. ఎందుకంటే ఇక్కడ పర్యావరణ సమస్యలు చాలా ఉన్నాయి. అక్కడ పర్యావరణం మీద జరిగే వాటిల్లో ప్రజలు కోర్టులకు వెళ్ళి దాని మీద పెద్ద ఎత్తున నష్టపరిహారాలు పొందిన సందర్భాలు ఉన్నాయి. ఇక్కడ ఆ పరిస్థితి లేదు మనకి. ఇక్కడ చట్టాలన్నీ మార్చేసి వాళ్ళు చేస్తున్నారు. కాబట్టి ఆ విషయంలో ఏమన్నా కొంచెం చెప్తారేమో అనుకున్నాను. అయినా ఇప్పుడు టైం లేదు కాబట్టి మేడం చెప్పింది చాలా బాగుంది. ఆవిడ చెప్పిన దాంట్లో మన దగ్గర ఉన్న ఎన్జిఓలు అంతా కూడా ఫ్రాడే ఉన్నారు ఎక్కువగా. నిజంగా అమెరికాలో ఎన్జిఓస్ ఒక కీ రోల్ ప్లే చేస్తున్నారు పబ్లిక్ ఒపీనియన్ మోల్డ్ చేయడానికి. ఇప్పుడు కొత్తగా వచ్చే జనరేషన్ మాళవిక గారు లాంటి వాళ్ళు ఇంకా అనేక మంది స్టూడెంట్స్ని తయారు చేసి ఇలాంటి జ్యుడిషియల్ యాక్టివిజం ఇండియాలో ప్రమోట్ చేయాలని, దానికి ఆవిడ దీన్ని ఒక పుస్తకంగా కూడా తీసుకురావాలని చాలా మందికి ఐ ఓపెనింగ్ గా ఉంటుందని. ధన్యవాదాలు సార్.
థ్యాంక్ యూ సార్. థ్యాంక్ యూ వెరీ మచ్. నందివెలుగు ముక్తేశ్వరరావు గారు.
రఘు గారు ప్లీజ్ పాస్.
పాసానా? రైట్ సార్. ఇంకా ఏమండి, దాదాపు అందరం అయిపోయినట్టున్నాము, పెద్దవాళ్ళం అందరమే. ఇంకా ఎవరన్నా మాలవిక ఫ్రెండ్స్ ఎవరన్నా జాయిన్ అయి ఉంటే if they want to share their views, kindly be sharp enough and straight enough. I request anyone on behalf of Malavika who joined here and wanted to contribute something to the discussion.
Yeah, it's Krishna Mohan.
Yes, please.
Yeah. Thank you.
నిన్ను తీసేసామా లిస్ట్ లో నుంచి కృష్ణమోహన్.
పర్లేదు.
చెప్పు చెప్పు.
చాలా బాగా మాట్లాడింది మాళవిక. ఇట్స్ ఎ వెరీ కూల్ అండ్ excellent presentation, very knowledgeable presentation also. I think she to start writing books on that. Let her start writing books that will be documented, whatever she has in her mind about her studies. As our professor said, she needs to have PhD on this law subject by comparing both the judicial systems of both the countries, her country and her working place, that is the USA. I wish all the best to her, and I know Malavika well. Thank you very much, Malavika, for your presentation very nicely. Yeah, as our commissioner, secretary told, it's a very cool presentation, and you lost no words, and all the time you have been talking to us very well, and we really enjoyed your talk and learned many things from you. Thank you very much. It's not that easy to compare both the systems, and with a very short notice, you have delivered this subject. Thank you very much. All the best to you.
Thank you all. Now I revert back to Malavika for her conclusive responses, including certain of the answers to the questions.
Yeah,
Narahari
thank
garu,
you so much.
One minute, Malavika. Some Narahari garu wants to intervene. Narahari garu, please unmute yourself. Unmute avali, మీరు ఇంకా అవ్వలేదు. Sir, unmute అవ్వలేదు మీరు. Yes.
Good evening to all. Of course, good evening may not be applicable to some people who are in various time zones. Anyway, good day to all. So I came here for the first time, I have been introduced by Patanjali to this meeting, but unfortunately, I got this intimation in the last minute, and I didn't see it for 1 hour. So in the last I came, and you were all interacting on the speech. One thing I can say is I just want to introduce myself. I like this kind of activity, and I am additional general manager in TCS, retired. I am an MA Sanskrit, and after that I have done LLB in Pendekanti. That's why I was really interested to see that a Pendekanti student has given this lecture. I congratulate her, and I really like the transition she has made from LLB in Pendekanti to BA LLB in Pendekanti to LLM in United States, and the way she is progressing. If a recording is available, I would like to listen to the speech later. And I just would say a little, and I'm really very, very appreciative of the people who are assembled here, who are having multifaceted experiences in various countries and in various fields. It is a very good group, I should say, because I have been listening to the interactions from the beginning. So it is very nice to be associated with this group. So from next meeting onwards, I'll try to make it regularly attend this. And very congratulations to Ms. Malavika, who is my, I can say, co-student of Pendekanti College. I did my LLB after retirement when I was 66. But after retirement, I even enlisted in Bar Council. But because of Corona started immediately, 2019 I finished. And so I could not do any practice. I wanted to do practice just for the sake of it for a few years, but it could not happen. I don't know whether it will happen now. It's nice to see. Thank you very much. Thank you for the chance given to speak.
Prakash, are you available, Mr. Prakash? Prakash. Okay. Malavika, now you can give your final.
Sir, just 1 minute. This is Chandra.
Please, sir.
thank you so much for taking your time out, first of all, to make this excellent presentation. And it was intriguing all through. And it was same for everybody. I think everybody would agree that for a legal background people or non-legal background people, they found it very interesting. And yes, this is a very huge topic. Everybody would agree for that. And to cover that with this precision and with this kind of presentation, I think you have done an excellent job. I liked it. And I want to again see the recording once more so that I could digest something. And I'm very happy that the translation you have made. And yeah, I'm proud of you for now. Thank you,
Thank
Malavika.
you, Anna. Thank you, Anna.
Thank you very much.
ఒక్క మాట బై ముక్తేశ్వరరావు గారు.
ముక్తేశ్వరరావు గారిని అడిగాను, ఆయన పాస్ ఓవర్ సార్. ముక్తేశ్వరరావు గారు
ఒక్క మాట,
ఇంకా పాస్ ఓవర్ టైం అయిపోయింది.
బీయింగ్ ఏ ప్రౌడ్ ఫాదర్.
ముక్తేశ్వరరావు గారు ఇంకా పాస్ ఓవర్ పెట్టడానికి లేదు సార్ అవకాశం.
అవునవును. Malavika, you have done a commendable job with so much of intensity of the subject. You could handle it deftly and finally landed in very safe conclusions. The interesting part is, in spite of its complexity, you could take all of us on board, and we could really learn very good points. And during the discussion that generated thereafter also is also very interesting. Something like a good follow. Thank you. All the best. Keep it up, Malavika.
Thank you. Thank you, Nana.
మాళవిక అమ్మని కూడా ఒక మాట మాట్లాడమని. అమ్మ కూడా ఫాలో అవుతుంది.
ఏ పేరుతో ఉన్నారు ఆన్లైన్ లో?
నమస్కారం అండి అందరికీ.
నమస్తే. నమస్తే.
చాలా చక్కగా మాట్లాడింది. 1.5 hours నాన్ స్టాప్ గా మాట్లాడుతూ ఉంది. నేను మంచి శ్రోతలాగా వింటూ ఉన్నాను. ఐఎమ్ వెరీ హ్యాపీ. మీరందరూ చక్కగా విన్నందుకు, తనను బ్లెస్ చేసినందుకు అందరికీ నమస్కారం.
థ్యాంక్ యూ అండి.
Thank you, Mummy.
Yeah. Now it's your turn, Malavika, to conclude the session with your responses.
First and foremost, I would like to thank you. Thanks to everyone for patiently listening to me and to encourage me with your kind words. It really means a lot. No, we don't. Also, I want to thank Raghu Kumar Uncle Garu for giving me this opportunity. This is one of those days, in my life where I actually woke up early and I'm attending something really worthwhile. I don't wake up this early. So it's also a new beginning to me in one way. Apart from that, this was a very challenging and very interesting topic to me, especially while I prepare for California bar exam and understand what is happening in India, reading the newspapers and understanding political discourse. A lot of connecting of dots had to be done by me, and I had kept in my mind this, like I said in initial remarks లో కూడా నేను చెప్పాను, క్లినికల్ అప్రోచ్ తక్కువ ఉంటుంది అని. క్లినికల్ అప్రోచ్లోకి వెళ్తే ఐ హ్యావ్ టు గివ్ అబౌట్ డేటా స్టాట్స్ అండ్ మళ్ళీ డేటా స్టాట్స్కి వెళ్తే మెథడాలజీ కరెక్ట్గా వచ్చిందా లేదా చెప్పాలి, ప్రైమరీ సోర్స్ ఏంటి, సెకండరీ సోర్స్, ఐ హ్యావ్ టు క్రిటికలీ ఎవాల్యుయేట్ ఇట్. ఫర్ మీ ఇట్ ఈస్ బెటర్ టు సీ వెదర్ ద గోల్ సెట్టింగ్లో అసలు ఎలా ఉంది జ్యుడిషియరీ అన్నది చూసుకుంటే ఒక మంచి పారామీటర్ ఏమైనా రావచ్చేమో జడ్జ్మెంట్కి అనిపించింది. అందుకనే విజన్ అండ్ ఆబ్జెక్టివ్స్ ఎక్కువ హైలైట్ చేసుకుంటూ ఏది చేస్తూ ఏ విజన్ని ఫుల్ఫిల్ చేశారు, ఏది చేస్తూ ఏది ఫుల్ఫిల్ చేశారు అన్నది తీసుకున్నాం. అలా తీసుకోవడం వల్ల ఇన్ సింపుల్ లాంగ్వేజ్ రెస్పాన్స్ స్టిమ్యులై లాగా దీనికి ఇలా అయింది, దీనికి ఇట్లా అయిందని కనెక్ట్ చేయగలిగాను. సో in that tone only I have prepared my PPT so that layman కి కూడా అర్థమవుతుంది. Also it's a opportunity to introduce new kind of legal topics to new people. So that's one reason I did not give quantitative stats. But in USA, if particularly needed to be asked, um, there are a lot of undergoing trial prisoners, but the best part about USA is they have so many rights compared to Indians. In India, a prisoner is a person who is in a jail doing almost nothing. But in USA, they are still part of the economy. They do pay taxes, they do earn. So they might be ongoing trial prisoners, but the numbers are very low. ఎందుకంటే కాన్విక్షన్ రేట్ కూడా కొంచెం హై ఉంటుంది. If they are convict, they'll stick around. సో అండ్ ఆల్సో లైక్ ఐ సెడ్ కరెక్షనల్ హోమ్స్ ఇవన్నీ ఉంటాయి అని నేను చెప్పాను కదా. ద ఎకో సిస్టమ్ ప్రొటెక్ట్స్ ద పర్సన్ హూ ఈజ్ ఏ ఆన్గోయింగ్ ట్రయల్ ప్రిసనర్. హీ ఈజ్ నాట్ ట్రీటెడ్ ఈక్వలెంట్లీ విత్ ద పర్సన్ హూ యాస్ ఎ వెరీ ఒక కల్ప్రిట్ అని ముద్ర వేసిన వాళ్ళతో కలిపారు. So there are too many segregations, too much of a procedure to follow with respect to what is how they have to be given punishment. So in that regard, I could vouch and say there are lesser number of undergoing trial prisoners compared to India. Um, but again, quants and stats are always about methodology. We don't know how many undergoing trial prisoners are real culprits. They could be proxies, right? We don't know many things as a matter of fact. So I didn't want to go into that direction. There was one more question on Guantanamo Bay. Someone was telling about what about the human rights in USA with respect to all these people picked up and thrown out into Guantanamo Bay and have been treated really wrong. So Dean Gurinchi Obama has given some policies. Trump has given some policies. చాలా మందిని రిమూవ్ చేశారు, చాలా మందికి ట్రయల్ చేశారు. బట్ the most agreeable fact to it is politicized and it is only used to influence political decisions. సో అమెరికాలో సర్టెన్ సెక్షన్ ఆఫ్ పీపుల్ వాళ్ళ దగ్గర నుంచి ఓట్ రావాలంటే గోంతనంలో బే వాళ్ళని తీసేస్తాము, లేదా వాళ్ళకి ట్రయల్ ఫాస్ట్గా అవుతాం, ఇలాంటి ప్రామిసెస్ వచ్చినాయి. సో ఇక్కడ నేను క్లినికల్గా డెల్వై చెప్పడానికి పెద్ద ఏం లేదు. ఆల్ ఐ కెన్ సే ఇస్ యూనో ఒక నేరస్తుడిని వదిలేస్తానన్నా, నేరస్తుడిని లోపల జైల్లో పెడతానన్నా, ఈవెన్ దట్ రిమార్క్ బై ఎ politician can be useful in making uh, vote bank. So that's a very political thing for me, but it is very unfortunate. It is a human right, a massive human right violations have happened ever since these arrests were happening. And Janardhan Reddy uncle has asked about stats. That's one thing I have again noted down. I have covered it in the first question answer. There was Hemant sir has asked me social and cultural changes and how they can be added to existing judicial system. For that, there are many ways one can actually add social and cultural aspects to the law. One of that being making that as an independent system. For example, like Raghukumar uncle has also told, Ambedkar has been very much against all these panchayati systems because there is a kind of subjugation, caste-based oppression, or otherwise gender-based oppression. It could take us thousands of years back, but also yes, that could be a rightful point. But there is also point of cultural appropriation of existing norms in a particular region. So we cannot strike a balance and say this is correct, this is incorrect. All we can do is go case on case basis by understanding people's conscience. If there is anything illegal, the court should intervene, which the court eventually does after the panchayat level of adjudication is done. So at the ground level, these are the things I can think of. And someone has spoken about um, no, that's my answer. Sorry. Yeah, I have written an answer to it, so that's my answer. Sorry. So, but thank you so much, everyone, for listening to me. This is my maiden speech, probably in my life. I feel really good and elated. I'm glad we are all on the same boat, sailing with pleasant memories on this day.
Oh, well, wonderful, Malavika. I think it's not even just, it's a very, very vast subject you have tackled within 1 hour, 1.5 hour, but you have given extensive information. In fact, beyond the comprehension of any advocate, practicing here in India. The subject, the way you have dealt with it, the coolness you have maintained all through the presentation, and the critical approach you have taken, they are all indicating that you are a very promising analyst, legal analyst. So hope you are, as one of your well-wisher has advised you to submit, probably think of a PhD on comparative study of Indian and American legal systems. But normally, you know pretty well that such a vast subject will not be allowed at the PhD level. You can just take either criminal justice or civil law or a particular area, so that it will be good for comparison. Otherwise, if you just say that Indian and American legal systems, it amounts to 5 to 6 PhDs. So it's a great thing you have done, and I really appreciate you because I have invited so many youngsters to deliver a talk. But always, in India, youngsters are always, they are hesitant to give a presentation to the elderly persons. They feel that they may put us into trouble, something like that. But without any kind of doubt, you have done the best possible presentation. I remember only one earlier friend who has given a talk on a idea of generational gap, and then yours is one of the wonderful talk given by any young person in this CSD. Thank you very much, Malavika, and we are all on behalf of the Center for Social Dialogue and on my personal behalf. I thank you and wish you a wonderful future. Thank you.
I just have a comment. This is Madhav, Malavika's brother-in-law.
Okay.
Hi. Sorry, my mic wasn't working well earlier, actually.
Okay.
Thank you for the presentation, Malavika. It was very clear and very clear knowledge on all aspects that you spoke on. Thanks for pulling me to this presentation, and it was very knowledgeful as well. Thanks all. Yeah.
Thank you.
Thank you, Bhavgar.
We have taken sufficient time of you, Malavika, and also the time of all elderly persons here. So I thank you all, and we'll come to the end of the session for today. And if you have any brilliant ideas to be presented to us, please feel free. And whenever you find time, you can make a presentation. You are always welcome. Thank you. Thank you. Thank you.
Thank you so
all,
much.
sir. Thank you all.
Keep Malavika seeing us on this platform with your talk or your presence. Okay, keep coming.
Sure.
Kindly experiment on us with your talk.
Thank you.
Sure.
Okay, all the best. Take care.
Thank you all. Huh?
Raghu Kumar also is an expert, law expert.
We're all old. We are generation saying goodbye.
Yeah, see you. Bye bye.
Thank you all.